Counsel, please proceed.
Good evening, Your Honor. May it please the court. My name is Ryan Pefferly on behalf of Appellant Blanche Braun. I would like to reserve 3 minutes for rebuttal. This case involves First Amendment issues, but before we get there, we have to address the jurisdictional and qualified immunity issues before we can even address the free speech terms. So I'd just like to jump right into the jurisdiction. My client, Blanche Braun, brought 3 claims initially, and after receiving an adverse summary judgment ruling based on qualified immunity on her free speech claim, dismissed the remaining claims without prejudice in order to get an immediate appeal on the qualified immunity ruling. Now, jurisdiction is proper in this case because the court properly certified this as a final order, despite the fact that the cases were dismissed without prejudice.
How did it certify anything? District Court certify under Rule 54B. I didn't see any 54B certification here.
I apologize. They properly dismissed the cases without prejudice in order to manufacture a final immediate appeal. I apologize for the misphrase. So in order to determine if the district court abused its discretion in granting this immediate appeal, the appellate court needs to consider a few things. First off, whether or not the failure on the adjudicated claims was required for success on the unresolved claims, and also if that's satisfied, then whether or not these attempts are to manipulate jurisdiction in order essentially to circumvent the system to get a ruling that she wants. My client is not trying to manipulate jurisdiction in this. She's just trying to adjudicate an issue relevant to each of her claims. And the reason for that is there wasn't any funny business going on here. She's just simply is not trying to shop judges or corroborate with opposing counsel to juke the system. But the reason that this is relevant is because courts have repeatedly granted immediate appeal when qualified immunity has been denied, but not necessarily when it's been granted. The reason they do this is because there's an interest in protecting government officials from taking part in trials, being sued, things that would disrupt the flow of government, and this also extends to pretrial, things like that. Now, by granting immediate reviews when qualified immunity has been granted, this allows that same efficiency standard because it allows the courts to pick out the legitimate suits that have been denied while still allowing a possibly wrong client to seek an adequate appeal. This still promotes government efficiency. It still allows claims to be brought without disrupting the government flow. Now, beyond that, going to qualified immunity, the main ruling on qualified immunity was that the law was not clearly established to the point that Radcliffe should have known better than to reprimand Braun for liking a racist Facebook page. The district court erred in reaching this ruling because the law was in fact clearly established at this point. Part of the district court's analysis was that the only case on par with this was the Bland case, the district court case, which specifically ruled that a Facebook like is not protected free speech.
And that was governing law at the time, right?
Well, not necessarily, because it was just district court law in a different district.
The only court in all of the country to have considered the question of whether a Facebook like is speech against First Amendment protection, right?
Yeah, well, in order for a law to be clearly established, you don't need an identical provision. You don't need identical circumstances from case to case.
But if you've got one, why can you ignore it?
Well, it was reversed.
But you'd agree with me that the time when you consider qualified immunity, you consider the world as it existed and the legal landscape as it existed when the defendant acted. Right?
Well, the legal landscape as it existed is based off the evolution of the law and whether or not the way the law has evolved has given Radcliffe in this situation fair warning that his actions are violative of Braun's rights. In this case, because of the Elrod-Branti doctrine, going back from the 70s and then was the Elrod case and then Branti shortly thereafter, both had rulings that public employers could not punish non-policy-making employees for speech if they were otherwise satisfactorily doing their job. And similarly, the Branti case ruled that that applies even to people, attorneys in a public defender's office. So that kind of ups the ante on what is a policy-making employee. And because the Elrod Branti doctrine existed well enough, a reasonable civil rights director in Radcliffe's position would have understood that by taking away someone's access to Facebook, by threatening to fire her over liking a Facebook page, was violating of her free speech rights. Because he's a civil rights director, a reasonable person in that situation, he probably handles free speech issues all the time. He's probably very familiar with free speech law.
I don't understand. Are you implying that Braun was a policy-making employee?
No, I'm saying she's not a policy-making employee. And I was saying that Radcliffe should have recognized that, and because of the fair warning doctrine, he should have known better than to punish her for that. And because Elrod Branti requires us to analyze Braun's duties, there's a two-part test brought by the Stott case, Supreme Court case from the 80s. And the first thing we have to consider is whether the position requires decision-making on issues where there's room for political disagreement. Now, Braun is a receptionist for the RCRC. So she's not a decision maker. She's not laying down policy. She's not the one setting the rules for the rest of the office. She's there to answer the phones and, in her words, take only enough information that's necessary to pass along. And because of that, her position's specific responsibilities don't really resemble a policymaker. Yes, she's the first person people talk to when they walk into the office, and yes, she answers the phone and talks to them, but she only serves as a liaison between the people who actually are the policy-making employees, the ones who do have to make the tough decisions, and the people who are coming in with qualms with the RCRC. Because of that, because fair warning existed, and because Braun's in a non-policy-making position, it's pretty clear that the law was in fact clearly established to the point that Radcliffe had fair warning that he shouldn't have acted in the way he did. And such being the case, that really qualified immunity should be overturned in this course. This court should reverse and remand for further proceedings on the qualified immunity basis. And then once it does that, it actually gives us the opportunity to look at the free speech merits of this claim. Before we get into whether it is her rights as a public employee were violated, we actually have to determine if the conduct herself constitutes speech that may be protected. The district court relied on Bland, which distinctly said that liking a Facebook page is free speech. That ruling has since been reversed. The reason that that was reversed is twofold, is the expressive nature of a Facebook like and Radcliffe's subjective perceptions when he saw Braun like the page. Now it's pretty simple that conduct is speech. The Supreme Court has established this long throughout history. Texas v. Johnson, the flag burning case, putting political signs in your front yard, raising a middle finger, having a tattoo. None of these are actually words that are spoken, but they've all been recognized as forms of free speech. Now when you connect this to the internet, where internet has been given the same free speech protections as other forms of speech, when you like a page on Facebook and you click it, it literally publishes the statement, Facebook user likes this page. Now when you see that read on the internet, how is that any different than a political sign in the front yard saying, owner of this house likes this political candidate, or I don't like what you just said, I'm going to give a certain hand gesture. So because it's expressive in nature, it's clearly speech. And also, regardless of her actual intent in making the speech, that's not entirely relevant to this situation because the controlling factor are Radcliffe's subjective perceptions of Braun's conduct. Yes, it's true that she only intended to bookmark the page for later reference. She didn't actually intend to say, I like Deerian Earhart motherhood. However, the declarant's intent is not controlling. And according to Texas v. Johnson, the flag burning case, it said it's not controlling when A, the opposing party concedes that a communication has occurred. Clearly that's happened in this situation because Radcliffe saw it and reacted to it and told her to remove the communication and that she was prohibited from making similar communications at work ever again.
So if I accidentally burn a flag, that gets First Amendment protection? Is that what you're saying? If I accidentally communicate something?
Yeah, as long as someone was there to perceive it as a communication. and as if the conduct is sufficiently imbued with elements of communication as well as the perception. So if you're just sitting there, you know, saying, hey, I'm gonna burn this flag because I like fire, or just because look at me burn this flag, that's probably not containing proper elements of communication. If it was in the middle of a protest or something, like I believe Texas First Johnson was, then it is more imbued with elements of communication. And in this case, it clearly is because of the text, the published statement that goes along with it that says you like something. It publishes a clear endorsement of a view. So in that case, it is communication and it's perceived as such, and therefore it's a protected speech act.
Doesn't Braun have to have an understanding of, I guess, what a like means? Like, wasn't that a big part of the Bland decision, the Fourth Circuit decision to overrule it?
That understanding, you mean that
Yeah,
she has to understand that she actually said she liked the page?
Yeah, the nuances of Facebook.
Not particularly, because it's out there, and once the statement is out there, it just comes down to who's there to see it. And if people see it, perceive it as an endorsement of the political views, then it's a message. Then it can be protected speech. And since it is protected speech, we have to come to the Pickering balancing test to determine if her rights were violated as a public employee. A public employee's speech is protected if the expression occurred as a private citizen, it addressed issues concerning the public, and the employer's interests outweigh those of the employees. Here, Braun was clearly speaking as a private citizen.